Okay, well, good afternoon, everyone. It's a little bit after 12 here, so we'll go ahead and get started. My name is Fawaz Baum. I'm an attorney with Hunt & Andrews Kurth, and I'm the Vice President of the DFW Muslim Bar Association. Thank you for everyone for joining us on Coffee and COVID-19 webinar on the legal impact of the coronavirus. Obviously, hopefully you've got your cup of joe and or lunch available. So just sit back, relax, enjoy our webinar. We're going to dive into a couple of topics that seem pertinent and where we're really seeing impacts of the coronavirus industry-wide. This webinar is being put on for attorneys. So it's to enable all of us to learn from one another, understand new developments, what everyone else is seeing in the marketplace, and hopefully learn from one another. So I just want to set the scene with that. We're also hopeful that you guys are keeping safe and healthy, both mentally, physically, taking care of your kids and your family. So those are very important to us, and we are here as a resource if you need someone to talk to in a professional setting or a personal setting. Please feel free to reach out to us via Facebook, via emails, and just giving us a call. We will absolutely be there for you guys. To that end, we're also going to do a virtual happy hour. Inshallah, we'll be doing that next week on April 16th at 6 p.m. That is the new craze at the moment, and we're going to jump on that bandwagon, and it'll be a good opportunity to talk to everyone, see everyone, and we'll send an invite out for that. We just announced that a little bit ago. Moving right through on the slides here, FYI, all lines are muted. Feel free to chat in the box if you're experiencing any audio issues, but hopefully you can hear each speaker at a time. Any questions can be submitted via the Q&A function on the bottom at any time, and we'll try to get to as many as we can towards the end. The session is going to be recorded for just internal resource purposes. And this is probably a good point in time to mention, if you haven't paid your dues for 2020, which goes from January 1st to December 31st, 2020 for this year, please go ahead and pay the $40. It helps us put on events and bring you guys resources. And we've got numerous ways to do it: Chase Quick Pay, direct payment via Clear Exchange website, payment through the Venmo app, and then old-fashioned mail a check to Hisham at Jackson Lewis at the address provided. I'll go ahead and drop that information into the text box at some point here so everyone has it. The other item to bring up is this seminar today. This webinar is CLE eligible, and at the end of the course, we'll provide you the course number so you can self-report, and we will also submit the roster of the attendees to the state bar as well. We're also working on a resource data site where attorneys can collect information from various CLEs, presentations, papers that will help everyone. So look forward to getting more information on that in your next digest in our subscription. And that brings up my next point. Make sure you join the Google group. Asad will probably go ahead and drop a link in the chat box to the Google group. He's our president, and we'll also publish that on Facebook and other platforms so folks know where to, how to get onto the Google group. And essentially what we're envisioning for the Google group is it being a better place to interact, serve as a referral base, have resources, and it's going to be a little bit better than Facebook. So anyhow, we can jump right in. Our audience today, essentially, as I mentioned, are attorneys. We're trying to give you guys practical tips that you can help your clients with and better yourselves in understanding the current situation. Today's topics, generally speaking, are going to be employment matters, landlord-tenant commercial leases, immigration law, and the CARES Act. We've got some great presenters here today from across the spectrum. We've got Hisham, Saba, Fawaz, me, Noman, and Riyadh. So we'll be hearing from each one of them as we go through this. So up first, we are going to have Hisham talk about employment, and I'll turn it over to him. And we can't quite hear you, Hisham, so let me try to unmute you. You might be on mute on your end. There you go. Hisham, you might have to move up your phone a little bit. It's coming a little lighter.
Sorry, can you not hear me?
Yep, that's perfect.
Okay, wonderful. So we're going to be splitting up this topic. I'm going to get the first half, and then subsequently the second half of this topic. It's a lot of information, and we're going to be doing this at a very high level, and we're focused specifically on the state of Texas. So if you're representing a business or representing an employee outside of the state of Texas, this may be different for them.
Hisham, sorry, I think you might have to move up your mic a little bit more.
Is that better?
That is way better.
Okay, sorry about that. Sorry for the technical difficulties. It's my first time doing a webinar, so let's see how this goes. All right, so I'm going to start off with the Families First Coronavirus Response Act. This one was passed back on March 18th. It amended the Families Medical Leave Act and also enabled emergency medical leave. It really only applies to employers who have less than 500 employees. And there's a carve-out as well for employers who have less than 50 employees if it would jeopardize their business. So it doesn't actually apply to most businesses throughout the country. There are some ways to count those employees based on if you have a joint enterprise or if you're operating in numerous states. The statute's not exactly clear on how you count those folks. But if you do have less than 500 employees, it does theoretically apply to you. And it allows for 80 hours of paid sick leave immediately available. And this statute actually already took effect back on April the 2nd. And so these benefits are already available to employees. And so employees have the ability to take these benefits first and then exhaust those. And then after those benefits have been exhausted, the employee would still be entitled to any other leave that they might have. So if they have PTO or if they're eligible for FMLA, the important thing here is it doesn't apply to all employees. It only applies to an employee who's subject to a federal, state, or local quarantine or isolation order related to COVID-19. That's going to be a very limited scope. And the employees been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. The employee is experiencing symptoms of COVID-19 and seeking a medical diagnosis, or the employee is caring for an individual who is subject to an order or the doctor has told them to stay home because of COVID-19. It also applies, the interesting carve-out, there's also a carve-out as well if you are caring for your son or your daughter because their school has been closed, and that's due to COVID-19. So there are a couple of different ways that it applies. It applies to all employees regardless of tenure. So it applies to your part-time, your full-time employees, and any unused sick leave does not carry over from this year into next year. And unless COVID-19 decides to pop up back in 2021, the statute probably won't see a lot of use other than in the next 6 months or so. Okay? So I'm going to go ahead and go to the next slide. The next thing, and this is really just because of the way Texas is. So I want to talk about paid sick leave and personal time off. Under Texas law, there is no statute that provides.
Hisham, your mic might have slipped up again.
Yeah, is that better? Thank you.
Perfect.
And I'll do my best to keep it up close. So we're going to follow the FMLA, the FFCRA, the Families First Coronavirus Response Act, and stay compliant with the ADA and other requests for accommodation. I want you to know that Austin, Dallas, and San Antonio have all passed local laws, but all of them have been enjoined because of pending litigation. We thought that the Dallas one would take effect a week ago, but it was enjoined on the last day of March. The most important thing to do is if you're representing employers or you're looking at policies is to follow your policies. The Texas Workforce Commission has said over and over and over again that we're going to just enforce your policy as written. So if your policy says that the employee must exhaust PTO or personal time off, or they must use PTO instead of sick leave, then make sure you just follow those policies, read them closely, make sure that they're up to date. And there are ways that you can change those policies. Even during this time, you could even change those policies because they're usually an exclusive benefit provided by the employer. Just be cautious about doing that. But I can go to the next slide. Good. And so I wanted to highlight some of the wage and hour issues that we're seeing in this area as well. Again, Texas doesn't have any specific wage and hour law other than, well, I say that, there is one law, but we're not going to get into it today. So we're going to follow the FLSA for wage and hour issues. So for your non-exempt or hourly employees, they only have to be paid for the hours that they've worked. That means if they're not working, then you're not paying them. For your exempt employees, they have to receive their full salary in any week they perform any work. There is also a minimum salary level here where if you've decided to reduce the salaries for your employees because you don't have enough work or maybe they're operating less hours, it's important to stay above the minimum salary threshold. And then in addition to that, we've seen a lot of folks are allowing people to work from home. Like, for example, I am working from home. If you as an employee typically incur expenses working from home, and the employer has to take into consideration reimbursing you for some of those expenses. So maybe, for example, they provide a cell phone stipend because you use your cell phone for work purposes. And not reimbursing any expenses may cause some issues for certain employers because you may lose the salary basis exemption. So be careful about that. There are ways to avoid that. The most common way is if you have managers, especially low-level managers, and they are maybe not supervising any employees right now, and you're at risk of losing the exemption, then you might consider switching them to an hourly employee for the time period. Again, you can use PTO, like making sure you're consistent with the policies. And I wanted to highlight here is that the Department of Labor has issued several FAQs and guidance, and that relates to FLSA, the Fair Labor Standards Act, as well as the FMLA. And I believe those are provided in the useful links at the end. If I can get the last slide, please. Okay, unemployment insurance. And I just want to highlight this at a very high level. So we know that the CARES Act, and we will discuss that later, supplemented the unemployment insurance, and that applies in Texas too. The maximum benefit here is $521 in Texas, and you can be eligible for benefits even if you have a significant reduction in hours. So if you've had, and there are guidance on exactly what significant reduction means. The important thing for when you're representing employees or employers is to note that you as a business cannot decide, and you as an employee cannot decide whether you receive benefits. You have to apply for benefits through the through the Texas Workforce Commission, and then they will decide whether you do or do not receive benefits and that level of benefit. Something we are seeing in this area is especially for minimum wage workers or tip workforce, you are going to receive more in unemployment insurance than you are going to receive if you had worked a regular work week. And I know we're seeing a lot of problems pop in that area. And so, again, I just want to highlight these at a very high level. I'm going to hand it off to Saba, and she's going to do the other half of the employment law issues.
Thanks, Hisham. Okay, so I'm going to touch briefly on furloughs and layoffs, which are words we are hearing a lot of these days, unfortunately. A furlough involves reducing the days or weeks that an employee works. You can think of it like an unpaid leave of absence with benefits. In a layoff, on the other hand, employees are actually let go, but layoffs can be temporary or permanent. With a furlough, employers have to take into consideration whether the employee is non-exempt or exempt for the same reasons that Hisham mentioned on his wage and hour slide. Employers can schedule non-exempt employees for fewer days or hours without liability generally. Exempt employees are a little bit more difficult because if they perform any amount of work during the work week, they have to be paid for the whole pay period. So turning to layoffs, some of the questions that come up are, when there is a layoff, is an employer required to pay severance? The answer is usually no, not by law, but it depends on what the employer's plan is, if they have an applicable severance plan. Another question that comes up is, can an employer subsidize health coverage even though an employee is no longer eligible as active? The answer is yes. An employer, if it wants to, can choose to subsidize health coverage either by subsidizing the cost of COBRA coverage or by relaxing eligibility requirements. Another question with layoffs is, whether it will impact retirement benefits. In some cases, a layoff can cause a partial termination of a retirement plan. This can occur when there's a significant reduction in participation in the plan due to a company-initiated event, like a layoff. The general rule of thumb is that a reduction of 20% or more in plan participation triggers a partial plan termination, requiring full vesting of the affected participants. And then when an employer furloughs or layoffs employees, it can trigger federal WARN or state mini WARN statutes that require employers to provide advance notice. Usually it's 60 days or 90 days, depending on the jurisdiction. And whether a WARN statute is triggered will depend on the length of the furlough or layoff and the size of the layoff. In Texas, we do not have a mini WARN statute. Next slide. So this topic is a stay-at-home and business closure orders. As of April 7th, when I drafted this slide, 43 states, DC, and Puerto Rico had implemented some form of a stay-at-home order. We've also seen many counties and cities implementing their own stay-at-home orders. Most orders contain exceptions for essential businesses and essential activities, but the definitions vary from order to order. The Texas stay-at-home order is effective until April 30th. The Texas order defines essential services as consisting of everything listed by the U.S. Department of Homeland Security and its guidance on the essential critical infrastructure workforce. Plus, because we are in the South, it includes religious services. The Texas Division of Emergency Management has a list of essential services online that you can take a look at. Governor Abbott has also implemented self-quarantine orders requiring travelers to the state of Texas to self-quarantine if they're entering the state from highly affected areas. There's an exception for traveling in connection with military service, emergency response, health response, or critical infrastructure functions. So if businesses have employees traveling between states, they need to be mindful of those orders because law enforcement are stopping people and checking, especially at the Louisiana border. Next slide. So what steps can an employer take to ensure safe workplaces? So I have a list of questions here. I'll kind of go through them quickly. Can employers screen applicants for symptoms of COVID-19? Yes, after making a conditional job offer and as long as they're doing it for everyone in the same type of job. Can employers send employees home who display COVID-19 symptoms? Yes, after taking into account current CDC guidelines, the EEOC has said that advising such workers to go home is not a disability-related action. Can employers request information from employees who call in sick? Yes, employers can ask questions about their symptoms to determine if they have or may have had COVID-19. The EEOC has said, again, that these types of inquiries are not disability-related, and even if they were, they're justified by a reasonable belief based on objective evidence that COVID-19 poses a direct threat. One thing to remember as employers, we must maintain all information about employee illness as confidential medical records separate from personnel files. Can employers take employees' temperatures? So generally measuring an employee's body temperature is considered a medical examination, but because the CDC and health authorities have acknowledged community spread of COVID-19, the EEOC has said that employers can take employees' body temperature. And again, the medical information is subject to confidentiality obligations. Can employers ask employees who do not have symptoms to disclose if they have a medical condition putting them at increased risk? No. So right now, the guidance is that making disability-related inquiries or requiring medical examinations of employees who do not have symptoms is generally prohibited by the ADA. Now, if an employee voluntarily discloses conditions or a disability that puts him or her at increased risk of complications, the employer can ask him or her to describe the type of assistance that they will need. And again, medical information needs to be kept confidential. Okay, so what should an employer do if it finds out one of its employees has tested positive for COVID-19? Does an employer need to contact local health authorities? No, employers don't have an obligation to contact local health authorities, but as a practical matter, local health authorities can help provide guidance on how to handle the situation. In Texas, the doctor who receives the patient's positive test and the lab that does the test, they'll report the results to the local health departments for tracking purposes. Does an employer need to contact OSHA? So under OSHA regs, employers have recording with a C obligations and reporting with a P obligations. Employers are required under OSHA's record keeping regulation to record with a C illnesses that are work related and meet one of the recording criteria, which includes the days away from work, job transfer, and medical treatment. Employers may be required to report with a P an employee's coronavirus infection to OSHA in certain situations. If the infection is work-related and the infected employee is hospitalized as an inpatient, the hospitalization has to be reported to OSHA within 24 hours of the incident. If the infected employee is not hospitalized and as an inpatient but dies from the infection, the death also has to be reported to OSHA if it occurred within 30 days of the work-related incident. And Texas does not have a mini OSHA regulation. Can an employer notify other employees that one of their coworkers has tested positive? Yes. If an employee is confirmed to have COVID-19, employers should inform fellow employees of their possible exposure in the workplace and send home all employees who work closely with the employee who tested positive to ensure that it doesn't spread. Before the infected employee leaves, employers should ask him or her to identify all the individuals that he or she worked in close proximity with for a prolonged period of time, which means more than a few minutes, in the previous 14 days to kind of gather a full list of who should be sent home. Now, employers should not disclose the coworker's identity to his other coworkers. So you need to have these conversations without actually disclosing the identity of the person who tested positive because of confidentiality obligations. Last question, can an employer require employees who have been away to provide a doctor's note certifying fitness to return to work? Yes, such inquiries are permitted under the ADA because they wouldn't be disability related, or if the pandemic is severe enough, they're justified under the ADA. But as a practical matter, doctors and other healthcare professionals may be too busy right now to provide this type of documentation. So I'd recommend, instead of overburdening the healthcare system, that employers accept other forms of documentation certifying that an individual does not have the virus. And that wraps it up for me. Here's a list of helpful links that Hisham and I have put together that contain a lot of helpful information that you can get from these agencies.
Thank you so much, Saba. All right, so we'll move over to residential commercial leases and contracts in general real quick. So as you can imagine, on the commercial lease side and these issues, there's not much regulation. So what we're going to do is kind of run through what we're seeing and issues to kind of be aware of, and some of these might be self-explanatory and known to all of us, but it's never too bad to get a refresher. As we know, on residential leases, generally there is no out, there is no inability to not pay rent for any reason. However, landlords, if the landlord is failing to provide a service, it can give rise to an argument to say that there has been a constructive eviction. So that's failing to provide utilities, garbage pickup, repairs and maintenance, building securities, or other amenities. And we'll get to that one in a second here. Commercial tenants, and backing up, sorry, on residential tenants, obviously every county's got a different moratorium going on right now on evictions. Generally speaking, on a residential tenant, as many of us know, a landlord, when a rent is late, a landlord can proceed on its way to the eviction proceedings. So they can place a note inside your apartment saying you haven't paid rent, we're going to lock you out. They can even go as far as to lock you out of your apartment. But under Texas law pre-COVID-19, all you have to do there is call your landlord or your client, call your landlord and ask for a key, the new key, and the landlord has to provide that key within 2 hours or otherwise jeopardize facing some statutory damages. So, and they don't have to pay rent in connection with getting the new key. It's just supposed to facilitate a face-to-face meeting and, you know, different outcomes. So the landlord can take it as far as to get everything prepped and ready for eviction, but really can't go to JP Court right now because we've got one, the courts are closed, and two, there's a moratorium on evictions. On the commercial tenant side of things, there are less protections, as we can imagine. The landlord could lock you out of your lease for failure to pay rent, but ultimately your lease is going to control how that process works a bit. What we have seen are arguments that both residential tenants and commercial tenants are trying to use with their landlord to secure some sort of leverage to figure out an agreement between the parties. And that really is a good outcome, right? Because from the landlord's perspective, if they're not permitted to let you on the premises, if they're not doing utility pickups or garbage pickups or not providing utilities, there's an argument to be made that you've breached quiet enjoyment, you have done constructive eviction. Now, obviously, that's going to be a very fact-specific determination that a judge would have to make. And a lot of case law on this seems to relate back to, did the landlord specifically do any wrongful action? And the challenge during our times here in COVID-19 is a landlord complying with a county order to shut down. Is that a wrongful action on part of the landlord? So it's going to turn on a very fact-specific scenario, and at this moment, we're not seeing litigation pursue going forward because the courts are limited in what they can do. But what we are seeing is tenants kind of making these claims that, look, both of us don't want to go to court to debate this. Give me an extension. So we are seeing it as more of a leverage point than anything else. Practical strategies. Many tenants are sending notices to the landlord stating that they're unable to pay rent due to COVID-19 and trying to request a rent abatement and deferral. So that's common, but there are issues with that as well. While there's no harm in asking for the relief, you're essentially putting yourself at risk in the lease to go into a default. It could trigger late penalties, default interest, loss of renewal expansion rights just by default in the lease language, acceleration of rent, and the start of the eviction process. And then it might also trigger recourse under personal guarantees. So it really is important to take a look at your lease to understand what the full ramifications might be. What we have seen when it does work is landlords are giving some rent abatement. They're doing rent deferrals. They're doing rent restructuring, which is essentially switching to some sort of percentage rent component, percent revenue component for rent, tacking the missed rent portion on the back end of the lease and extending the term out. So we've seen a couple of promising signs, but the landlord is under no obligation to be accommodating. So we want to review our leases to understand the full scope of, what does the tenant have right now and what is it asking for beyond. Inherently, there's the risk of the anticipatory breach. When you say, look, I can't make rent on May 1, the landlord may take it as far as to say, you breached your lease. I'm going to start the eviction process now. Now, there are some state safeguards in place for residential tenants, but on the commercial side, those are a little bit lighter. So it's important to have perhaps some verbal conversations with your landlord, but ultimately distill that down into a written agreement to kind of maximize the effect on both sides. So the CARES Act, fortunately, directs the funds to the tenants. It really doesn't spend money directly into the landlord's hands, except for the PPP program and other aspects of payroll, which should help the landlord during these difficult times. But essentially, the crux of it is, and what a lot of landlords are doing is, I will defer your rent, but I require you tenant, it's commercial tenant, to apply for the CARES Act benefits and then immediately agree that you will use those funds upon receipt to pay rent. So definitely offer those options to landlords to make this transition easy. So it's, it's reasonable that you're thinking ahead and you want to pay the landlord. That might help facilitate a resolution. There are limited forbearance protections for the landlord and in the CARES Act. And what I mean by that is under the CARES Act, under Title 4 of the CARES Act, there's the Coronavirus Economic Stabilization Act, which is CSAG, as everyone is calling it. And essentially there, if a landlord has a single family or multifamily residential property that has federally backed mortgages, the CARES Act has built in a forbearance option for those borrowers. So this is now from the landlord's perspective. For those borrowers, it's also put a moratorium on when evictions can take place. So again, this only applies to loans that are guaranteed by a federal program, Fannie Mae, Freddie Mac, and it's supposed to ease the burden on the landlord, so the landlord can then ease the burden on its tenants and things can flow in the normal course. So I encourage everyone to look at that option if a landlord is struggling, one of your clients being a landlord is struggling. The requirements under that program are not too stringent. You have to certify that you're going through a financial hardship related to COVID-19, but there really isn't any sort of backup support that's needed beyond the certification. The servicer of the loan is directed to immediately enter into a forbearance option, and the eviction moratorium is set without any sort of needing to submit any sort of paperwork on it. There are a couple of caveats that everyone should be aware of. The financial hardship mechanism of forbearance only applies if the landlord was otherwise current on their loan as of February 1. And but if they were, then that forbearance period can go up to December 31st, 2021. There are a couple of requirements on how the extensions will work and how the servicer has latitude to grant those. But generally speaking, it's a good option for landlords. Issues for landlords to be aware of, while you're working with your tenant, you want to make sure you're giving them maximum flexibility, but you also want to make sure you're protecting yourself. And what we're thinking about there is the commercial tenant side of things, is if you grant forbearances and deference of payments, what is that setting you up for? And mainly here, what we want landlords to be aware of is bankruptcy protections. So in the event that you give the tenant 30 more days, 45 more days to pay their rent, ultimately they can't. It's a commercial tenant and they file bankruptcy. You might be in a worse position. So what some landlords are doing is saying, okay, you defaulted under that loan, under that lease. We're going to come up with an agreement where I am terminating your existing lease and going to a shorter term lease. And the reason for that is just basically, I'm not a bankruptcy attorney, but there's a lot of nuance in bankruptcy law that is applicable when it comes to assuming a lease in bankruptcy. So if you have a shorter lease on the books with your tenant, that then allows you to have a better result if you get through the bankruptcy process. We're also seeing a lot of landlords ask, okay, I'll give you the deferral, but I want a letter of credit from your bank that I could draw on, and I'm not going to draw on it for a period of time. I want to increase your security deposit so I have a bigger claim in bankruptcy if you ever go that route. We already talked about the additional rent clauses, about the percentage rent, and a couple of the other workouts. All agreements should be distilled in writing, so you don't want to open the box of, oh, I had a verbal agreement with the tenant, because the tenant might come back and say, oh, I also had a verbal agreement, and you've just voided perhaps the integrated clause in your lease. So we want to stay away from that. Also, a couple items to be aware of in bankruptcy: there's a limited preference risk. If a tenant has paid you rent and thereafter in May or June files bankruptcy, the bankruptcy court's going to look for any preferential treatment to landlords. Now, as long as it was above board and in compliance with your lease, you should be okay as a landlord. But if you ask for extra money, came up with a special extra arrangement to benefit you to the detriment of others, the bankruptcy court might undo that. And then last point on bankruptcy about the automatic stay. Obviously, if a tenant files a bankruptcy action, you're stayed. Even if the courts are open back up, you can't start the eviction process. Bankruptcy courts are kind of leery about ipso facto clauses where tenant breaches a financial covenant and then boom, they are in default, and you're now proceeding to evict them. So there are a couple of items to be aware of, bankruptcy related for the landlord. Just real quick, I'll go over a couple other hot button issues that we're seeing on contract agreements in general, but again, relating back to leases and loans and commercial transactions here. Force majeure, hot topic. Force majeure, meaning superior force from the French language, has its genesis in civil law. So which basically means it's not going to be something that a court can imply into any contract. It is something that is a product of contract negotiation. So if you look at your lease agreement and there's no force majeure concept, a court is likely not going to imply that in there. So a lot of tenants have been calling going, do I have this concept? And if you don't, you don't. But if you do, you're still not off the hook, because force majeures are usually tied to very specific items, such as if you have construction that you were going to do to your premises before you were going to open up as a restaurant. The force majeure concept might help you delay construction, but not excuse you from construction. And usually force majeure does not apply to rent. Most landlords will not say, look, if something happens, I'm going to let you off rent for 60 days. That generally is not the case. But you need to really read the force majeure language, because many landlords are taking the position that pandemics are not covered under force majeure. It does not fall under the act of God, and there's a good case law on their side where an act of God is hurricanes, it's storms, it's not pandemics. That might change, obviously, with litigation that comes out, but that's generally what we're seeing at the moment. A couple of common law provisions then, if you don't have force majeure, that folks are trying to use again as leverage in their conversations for their transactions: impracticability, frustration of purpose, and prevention by government regulations. And there's also some UCC assistance as well on delays. But each one of these items, is going to be tough. They're seldomly used on a day-to-day basis in our transactions, as we can imagine. They harken back to our law school days when we were talking about them. So I've got a couple of definitions there and each one of these is going to vary by jurisdiction, obviously, as well. Impracticability, usually courts will require more than just saying, I didn't have the money, or my supplier didn't provide me X, so I couldn't build Y to sell it to consumers to make money to pay my rent. Usually courts will look into a higher threshold. So just be aware of that. Frustration of purpose, a lot of courts have come down on the side of foreseeability. That if it was foreseeable, then you really can't rely on frustration of purpose. And foreseeable, as we all know, very generally defined. But the thought there is, I didn't know COVID-19 was coming. And the other side can say, yeah, but we lived through H1N1. We lived through many other pandemics, not on the scale. So you should have known, we should have known this was foreseeable. You cannot rely on frustration of purpose because you should have envisioned a shutdown. Again, I think all of this is for more leverage purposes. Not any of this is being litigated at the moment that I'm aware of on COVID-19 context. But as you're having those difficult conversations with landlords and different transactions, these doctrines are helpful and hurtful on both sides. And prevention by government regulation is what it says. Obviously, the government is instituting moratoriums and trying to direct actions of private actors that also may help excuse some things going on here right now. I'll switch it over to Noman.
All right, what about now?
Perfect.
Good, okay, I just had to take it off mute. All right, so how is COVID-19 impacting the immigration arena? So the major impact right now is with the USCIS field offices. On March 18th, USCIS announced closures for all the field offices through the remainder of March. And then at the end of March, they continued that for all of April up until May 4th. So for the next month or so, all field offices are going to be closed, not just the one in Dallas, but all over the country. So that means no adjustment of status interviews, no citizenship interviews, and no biometrics appointments. What USCIS has said about this is that although the field offices are closed, all interviews are going to be descheduled. So your clients will receive letters in the mail letting them know that their interviews were descheduled. So the letters will say something to the effect of, due to unforeseen circumstances, we have to deschedule your interview and you'll get a rescheduling notice later on. So as attorneys, we don't have to actually request rescheduling or approach USCIS about this. USCIS has said that they will affirmatively reschedule the interviews when their offices reopen, hopefully on May 4th or sometime shortly thereafter. But until then, all those interviews that were scheduled between March 18th and May 4th are going to be descheduled, and that includes fingerprint appointments. Similarly, no oath ceremonies are going to be taking place until the end of May, most likely at the earliest. Right now in Dallas, they shifted oath ceremonies from the local field office to the Plano Convention Center over the course of the last several months so that they could swear in more people. Towards the end of March, I reached out to the rep at the Plano Convention Center who was doing oath ceremonies, and she confirmed that for the next 8 weeks, they're not going to be doing oath ceremonies. So that was at the end of March. So that's where I'm getting the end of May timetable. So if your clients are asking you, I completed my citizenship exam, I've been approved, I'm just waiting for my oath ceremony, you can let them know that they likely will not get sworn in until the end of May, if not later than that. Regarding employment-based applications, so the main issue with employment-based applications right now is that USCIS has suspended premium processing for all I-129 and I-140 petitions. So from a practical standpoint, in terms of I-129 petitions, that impacts a lot of H-1B workers. We're getting a lot of emails from clients telling us that they were laid off and they're on H-1, or that they were furloughed and they're on H-1 and they need to file an H-1 transfer. So those H-1 transfers can still be filed, but the problem is that they can't be premium processed. So those employees won't know if their cases are approved for several months. So as many immigration practitioners know, you can still file that H-1 transfer under normal processing, and they can work for 240 days while that H-1 transfer is pending. From an I-140 standpoint, with no premium processing available on I-140 petitions, if you get an approved labor certification in EB2 or EB3, you're probably better off doing a concurrent filing, the I-140 and the adjustment of status application together, rather than breaking it apart and doing the I-140 first and then the adjustment of status. Typically, that's what we did. We did the I-140 first, get it premium processed. Once it's approved, then file the adjustment of status application. But with no premium processing available in I-140 petitions, you're better off just doing a concurrent filing, because if you wait and break it apart, maybe 6 to 8 months before that applicant can file the adjustment of status. So it's better to just do concurrent filings in these situations. And so obviously these things are happening because USCIS, like all businesses, is being short-staffed right now. They don't have enough adjudicating officers to process cases under premium processing within a 15-day timeline. So that's why they're having to take these remedial measures. We can do the next slide, Fawaz. All right. So how is it impacting foreign embassy processing and consular processing? Well, it's the same. I'm getting emails now from the National Visa Center that say that they have reduced workforce. So cases are now going to be taking a lot longer to process with the National Visa Center. So ordinarily, when you would submit documents and maybe hear back after like 2 weeks to 6 weeks, maybe a couple months to 3 months before you hear back on the submission of your civil documents because they're understaffed. I'm sending in a lot of inquiries, and they're saying the same thing, that they're not responding to inquiries quickly because they're understaffed. So that's going to be a delay also. Embassies around the world are closed. So all interviews that were scheduled for clients at foreign embassies are going to be delayed. That's going to delay the whole consular processing timeline. If you have clients that are currently going through National Visa Center processing, what I would advise them is that any timelines you've previously given them are not going to be applicable. It's going to take several months to go through NVC processing, and at that point, once NVC processing completes, the case is just going to be put on hold until embassies will start rescheduling clients for interviews. and they have to first clear their backlog of previously scheduled interviews before they can start taking on new cases. So you can tell your clients right now to expect at least another 2 to 4 month delay in National Visa Center processing. I think it's important as practitioners to just kind of affirmatively tell clients to expect delays right now, because everybody around the world is dealing with COVID-19. They understand that their lives are just kind of been put upside down. So it's better to get that out there now, because I find that clients are more understanding if you tell them, hey, expect a lot longer delays in petitioning your spouse or your parents, et cetera, because these embassies are closed and the National Visa Center is taking a long time. I think they'll tend to be more responsive and accept those explanations. Regarding immigration courts, right now you can do master calendar hearings telephonically. That's generally been the rule of thumb. If you've ever been to an immigration court, you know it's not practical to go right now. You know, immigration courts are typically small. You have like 50 people, applicants and attorneys in a congested environment. So it's a very easy way to spread COVID-19. So master calendar hearings can now be done telephonically. Most of the attorneys I've talked to are requesting that if merit hearings are currently being scheduled, they're requesting continuances on those so they don't have to actually go to the immigration court and try a case. If you do have upcoming merits hearings, I would request or recommend making an appointment or contacting the court and requesting that those merits hearings be continued, and requesting telephonic appearances for masters. Do the next slide, Fawaz. There is a little bit of good news in the immigration arena. Most importantly, USCIS is still processing cases. That's very important. So if you have clients that want to file citizenship applications or adjustment applications, or they need to apply for renewals of their work permit and travel document, USCIS is still processing those cases. So you can still file them, they can still get processed. That's good for practitioners. We can still file cases, and obviously it's good for applicants. They can still get their immigration benefits on file. One thing that you should advise clients of is whatever timelines are posted online or whatever timelines you've previously given them, you can expect extended delays, but they can still file those applications. EAD renewals are given kind of preferential treatment right now. USCIS has said that they are going to use previously submitted biometrics. So typically when you file an application to request an employment authorization document renewal or EAD card, USCIS will request that you appear for fingerprints. But since biometrics and fingerprint appointment offices are being closed, they're waiving that requirement so people can get their EAD sooner. Since health benefits and employment benefits are naturally tied to EAD cards, they're giving those a little bit more of a preferential treatment. So your clients may get notices in the mail that say that we are going to use your previously submitted biometrics appointment on file so that we can process this EAD request. The other good thing that USCIS has said is that all requests for evidence, notices of intent to deny, notices of intent to revoke, and notices of intent to terminate are going to be given an additional 60 days to respond. So if you got an RFE or NOID that was dated between March 1st, 2020 and May 1st, 2020, then you can take whatever days they gave you and add an additional 60 days to respond to that request for evidence or notice of intent to deny. So for example, if you got an RFE on March 15th, 2020, and USCIS said you got a reply by July 15th, 2020, let's say they gave you 90 days. Well, now that's automatically extended into an additional 60 days. So in this situation, you would have until September 15th, 2020, basically an extra 60 days. So check your RFEs, your NOIDs, your NOIRs. If any of those are dated between March 1st, 2020 and May 1st, 2020, add an additional 60 days for how much time you'll have to respond to those requests. But that's it in terms of immigration. So I'll turn it over to Riaz now to talk about the CARES Act.
Okay. Assalamu alaikum. Can everyone hear me? Okay, great. So yeah, let me clear my screen here. Okay, let me take a minute just to introduce myself, since I don't think any of you know me. So I am Riaz Karmali. I'm a partner at Pillsbury in Silicon Valley and San Francisco in our offices here in California. So what's my connection to Texas? I actually went to college at Rice, and so get down there probably a couple of times a year. I'm a judge of the Rice Business Plan competition, and we have an office. We have 2 offices in Texas, so I have some clients and lots of friends down there. And I've been practicing for over 30 years. I'm on my 7th firm, always in private practice. Last 7 years I've been at Pillsbury, and would be happy to be a resource to any of you. My email is on the slide deck, and you can find me on LinkedIn, and my phone number I think is at the end of the deck as well. So feel free to reach out to me, not just for CARES Act stuff, but anything I could help with. I'm happy to talk. In terms of the CARES Act, I'm really just going to focus on the Paycheck Protection Program loans. And the CARES Act is just a huge act that I don't think is in anyone's head in any way. So, you know, we all have kind of looked at different pieces of it. And I'm just going to talk about the SBA loans available under the Paycheck Protection Program. There were 2 main SBA programs that were affected by the CARES Act. The Paycheck Protection Program is the main one, and that's $350 billion in loans which are intended to be forgivable was given. And then there's also economic injury disaster loans, which is the existing disaster loan program that was usually used for hurricanes and whatnot. And COVID-19 has been, you know, certified as a disaster. That's available. And that the good thing about that program is there's an ability to get $10,000 grants pretty quickly under that program. But that's, you know, reasonably straightforward. And I think where kind of the more money and sort of more complexity is on the PPL part, and that's what we're going to look at briefly here. So this is what the application itself looks like. It's very simple, as you can tell. It's 2 pages. Got some requests for information and certifications. And, you know, the problem is some of the details, they're not clear exactly what they're looking for, just from if you just read what's on the application. So the average monthly payroll and the number of employees are things that we'll talk about now in a little bit more detail. So we can go to the next slide for us. So as a threshold of eligibility to be a small business concern available for these loans, you have to be in operation on February 15th, 2020. So you can't go create a company today and apply. That's not going to work. You have to be eligible as a small business concern, which generally means less than 500 employees. That has actually been waived for companies in the hospitality and hotel, you know, industry. But generally, that's what it means. Although how you calculate those employees is a trick. So we'll get into that in a second. And you have to be able to certify that the loan is necessary to support ongoing operations and will be used to retain workers, maintain payroll, or other allowable uses. So you can't take a loan to go, you know, acquire a business or something like that. Next slide, please. So going into a couple of those, you know, boxes, the average monthly payroll is fairly straightforward, but it has to be just your, you know, U.S. employees, not consultants, and you cannot include any salaries in excess of 100,000 annually. So if you know the CEO is making 200,000, you can include their salary, you know, up to the 100,000. And you look at the average salary over the 12 months preceding the application and multiply it by 2.5. That's the loan that you're available for. Next slide, please. So the number of employees can get tricky because here you have to count affiliates, and we're going to talk a little bit more about affiliates in a second. And you also have to count employees outside the U.S. So for the number of employees, you have to look at your foreign subsidiaries, et cetera. So if you have 200 people in your business and 10 are in the U.S. and 190 are outside the U.S., you look at the number for this test. 200, you're less than 500, fine. But then in terms of the payroll, you just look at the payroll in the U.S. And there's an ambiguity here, but we think it's pretty clear that you have to have 500 or fewer globally, not just in the U.S. So I think we think that's going to get fixed. Next slide, please. So the affiliation is where it's going to get tricky, and I represent a lot of venture-backed companies, and it's extremely tricky in my world. But basically, if you're a securities lawyer and you're used to the definition of affiliate or just the general contractual definition you see in a lot of contracts, that's not the definition the SPA uses. So the SPA looks at control, but they include negative control. So clearly, someone who has 51% of the voting stock, they're an affiliate, and you would need to include, not only their employees, but the employees of any business that they control. So if if you have a private equity fund that's an investor in your company that has a majority of your shares, you would have to not just look at your own employees, but you have to look at all their portfolio companies' employees. And chances are you're not going to qualify. You're not going to be a small business under that test. The interesting thing in the venture context, we have a lot of my clients have minority investors that don't really control the business. They have maybe a board seat, but they have what could be considered negative control. They have protective provisions in their governing documents where they basically you can't do certain actions without getting the approval of the preferred shareholders. Or sometimes it's the board. The board director who's been nominated by the preferred shareholders. And in those cases, we have to look exactly at what those controls are. And the SBA has had a lot of cases over the years that one would have to look at and see, is it considered something that rises to kind of a day-to-day operation? If it's a veto over a day-to-day operation, then it's considered to be control, and you would have to look at all of the entities that they control, include those entities in your employees for the purposes of whether you qualify as a small business. And if on the other hand, their controls are just on things that are extraordinary, then you're okay. You don't have to count them as an affiliate as long as they don't have 51% of your stock. So what we're doing now is we're actually amending some of these governance documents to take out problematic control provisions so that our clients can qualify. Go ahead to the next slide, please. There's just kind of more detail around what I just talked about. So next slide. And then there's this question 3, which is a little confusing, where it seems to talk about 20% owners. It seems to talk about owners generally. And we think that the right way to approach this is to really look at the affiliate definition that I talked about. And if there are any affiliates, you have to fill out this addendum A, which they don't give you a form of, but you have to sort of disclose who the affiliates are and what their employee counts are. And we're actually taking this opportunity to explain, even if we think there are no affiliates, but we think the SBA or the lender might think that there might be because we have, they know these are venture-backed companies that we're working with. We actually explain on the addendum, why we think there are no affiliates, and that we've actually looked at every investor, and we're hopeful that that will help the loan application go through. Next slide, please. And then applicants have to make certain certifications that you're eligible to get this loan, that you have the right size of business, that you're going to use the loan for allowable purposes, and that you'll use it generally for payroll. And importantly, that current economic uncertainty makes the loan request necessary to support the ongoing operations of the applicant. And a lot of people have been talking about this in the press as if it's free money, and it's really not. I mean, I think that you have to be able to make the case that but for the loan, the company is going to have to take certain actions, reduce costs, do layoffs, et cetera, and that this loan is necessary. And so that's that's something that even I've got a lot of clients that have started to line up for this loan and now are thinking twice about whether it's going to be questioned not just legally, but maybe in the media or politically, et cetera. So people are thinking twice about, whether they really, whether the risk justifies it. Go ahead, next slide, please. And the risk in terms of, legal, criminal is significant. I think, these kinds of penalties here, 30 years in jail and $1 million fine. I mean, that's going to be for people who are really defrauding stuff. And I think if you're proceeding in good faith and you believe there's a case to be made and you've gone through all the checked all the boxes, you're probably, not going to go into have a lot of criminal liability, but this is there. There's False Claims Act is possible too. They've already appointed a new inspector general. I mean, the SBA isn't anticipating fraud in the program. So, people do need to be careful, and they should be, talking to their lawyers and talking to you all about doing this the right way. So anyway, I think my time is up, and thanks for giving me the opportunity. And I think we'll have some questions, probably.
Great. Thank you so very much, Riaz. Yes, so I know we're tight on time, but we wanted to make sure we answered a few questions. It looks like during the process we have been answering a few immigration questions, landlord-tenant questions, and also some employment questions. So I'll wait for any more questions to come through now that we're at the end of the presentation. But I'll take this time also to say, feel free to connect on the DFW Muslim Bar Association Facebook page, the Google group that us had sent over in the chat box. Reach out to the speakers, as Riaz mentioned, and everyone else. I've got their email addresses there, but you can easily find them on LinkedIn and Facebook as well. The course number for the CLE is 174082792. It's up there on your screen. You will have to self-report. We are CLE approved, and we'll send over the roster of the attendees. But feel free to self-report as well. The dues, just as a reminder, again, is $40, and those are a couple of options to pay. And we can continue to put on some great program like we have here. I'll turn it over to Hisham real quick because I know he had a question from Hasib, which he's answered, but it might be beneficial for everyone to hear. Hey, Hisham.
Okay. So I'll try to be quick. I know we're at the end of our time. So Shabazz asked earlier for staffing agencies who are considered joint employers with their clients are wondered which party is the employer under the CARES Act in regards to all those temporary workers that are placed by the agency with the client. And so, if you're asking for purposes of the PPP loan, I'm not sure I know the answer, and we also need to answer on that. For purposes of the employer in most cases, though, usually both the worksite and the staffing agency are considered joint employers. I haven't seen any additional guidance from the Department of Labor on that issue, but I will check and let you know. But in most cases, I would apply the same tests that are available under the FMLA and FLSA for determining who is a joint employer. Practically, they probably both be responsible. And I would just caution that if the worksite employer is now trying to argue that they're the employer, or the staffing agency is trying to argue that they're the employer now, that may have implications greater well beyond the CARES Act. So when an employee later brings an employment discrimination claim and neither the employer or the worksite or the staffing agency want to take responsibility for that, you may have already admitted basically that you're the employer by saying, yeah, we counted them under the purposes of the CARES Act. So I would just caution that. I would take a look at the contract between the two parties, between the worksite and the staffing agency, and see if there's additional guidance there about who they get counted, who pays the payroll, but that may not necessarily mean who's the employer, who has a responsibility to basically provide for the employee or care for the employee, that sort of thing, provide benefits and those types of things. So if it's for purposes of the CARES Act, then I'll let Riaz answer at least that portion. And before I hand it off, though, Soba, did you have any additional guidance on that point?
Nope. I agree with everything you said. I think it depends on the facts of the situation and what the contract says.
Yeah, I think in terms of the PPP program, we're still waiting for more regulations to come out. And that's the first question you asked is a bit of a tricky question. It seems like either of those co-employers could claim. So I'm not sure the answer. I think we'd want to wait for all the regulations and think about it. And I think you'd also want to sort of take a consistent position for both the number, like for example, if you're not claiming them because you want to stay under the 500 number, you certainly wouldn't claim them as part of the payroll number for calculating the loan, right? You'd want to take a consistent position. And in terms of the second question, the loan amount received through the PPP allowing you to pay all payroll via the funds or only sick pay or pay while the employee is out. Yeah, you can pay all payroll via the loan funds through the PPP. I think that's clear.
Great, thank you, Riaz. We have one last question, I think, which comes in from Rachel Ryder. Where do we submit the Paycheck Protection application, I think payroll application, a bank or directly to the SBA?
Really good question. Generally, the best way is through the bank. I think the SBA is trying to set up a portal, but we've seen the government's success with portals and various things. And if you go to that portal, then they would try to find you a bank. I mean, I think the best way is to go to the bank that you have a relationship with, and hopefully they're an SBA lender. But that's the way most people are doing it.
That's fantastic. Well, I know I want to keep everyone on time, and thank you everyone for volunteering their time to speak today. We hope this was helpful, and we'll go ahead and get the presentation material out to the folks that registered, and we'll try to keep these webinars coming every so often. But thank you again for attending. As a reminder, your dues, and number 2, sign up for the Google Groups. And we've got our virtual happy hour next Thursday at 6 p.m. Look out for an invitation to that as well, so we can all catch up more on a personal basis. Thank you very much, everyone, and stay safe.